is always a thing to be watched and heard. Without taking much time, since we know that it's a Sunday and people would like to slightly relax, but the passion to learn from a speaker like Justice Pius is always a pleasure. Over to you, sir.
Thank you, Mr. Vikas. Good evening to everybody, and particularly to Mr. Vikas yourself. Then we have Advocate R. Ranjit from Kerala. We have Advocate Saji Raphael, who is in fact the convener of my own Academy for Continuing Legal Education. Then I can see Shiva Sharath, whom I believe will become a judicial officer shortly. And the other faces, unfortunately, I do not know that. Then Sunil, my disciple, Sunil from Trivandrum is there, and everybody. And good evening to all the participants. Let us get down to business. The other day, he had started dealing with decisions. Of course, during the course of my lecture, also I had referred to decisions. But then I had started dealing specifically with case law, mostly Supreme Court decisions and one or two Kerala decisions also. Now we will continue with that. The first decision which I want to refer you to today is a judgment of the Supreme Court. Citation is 1996 5 SCC 468. And give only one citation, 1996 5 SCC 468. And the learned judges are, which consisted of Justices M.M. Punchi and K. Venkataswamy. Then cases DCM Limited and another versus Union of India and another. Which had applied for and completed their expansion projects during 1/11/1975 to 2010/1980, granted incentive of higher percentage of levy-free sugar quota. Subsequently, control on sugar lifted with effect from 16/8/1978, as a result of which classification, levy and levy-free sugar ceasing to exist and benefit under the incentive scheme of 1975 no longer required. But with effect from 17/12/1997, sugar policy again modified, providing partial control with the dual pricing as existed prior to 16/8/1978. Government, before refusing the incentive scheme of the year 1975, have taken into account various factors, including the decontrol of sale of sugar for the period from 16/8/78 to 17/12/79. Benefits under the subsequent scheme in force from 15th November 1980 has already been accorded to them in full measure, according to the petitioners, DCM. Held on the facts of this case, the principle of promissory estoppel has no application at all. Administrative law, promissory estoppel, nature and applicability based on equity. Doctrine is applicable against the government in the exercise of its governmental I tell you, friends, that most of the decisions which I came across and which I propose to refer to are all of the Supreme Court are in the context of promissory estoppel, which actually is not a regular estoppel in the strict sense of the term. But since, those cases are in public law, no wonder promissory estoppel is the common subject matter of all these decisions. Now, I take you to, I told you the other day itself that I will be citing a decision of the Bombay High Court, and the author of the judgment being a judge who was in my parent High Court, Kerala High Court, then transferred to Bombay High Court, and now he has demitted office, he has resigned, and we are given to understand that he is going to start practice. He is going to don the robes of a lawyer again. A very brilliant man, very learned man, Justice Dama Sheshadri Naidu. So this is Justice Naidu's judgment. The citation is AR 1920, Bombay 31.
He has already appeared. It was reported in Bar and Bench.
Oh, I see. He was very friendly towards me. He had been sponsoring prizes for my academic quiz competition. Yes.
He has come on our platform.
Dama Sheshadri Naidu. Then case is Vasanthi Sridhar Bangera, doctor and others versus Vishala Bogapatana Lakshman. This is the case. Now, Code of Civil Procedure, section 24, because that also, in fact, even though I am only reading those parts, those portions of the judgments pertaining to my topic, Estoppel, I expect you as students of law to read the whole decision, because, especially in Naidu's decision, is authority for several other important propositions of law, which will be relevant in your day-to-day practice. Anyway, section 24, the transfer powers. Then Estoppel, suit for eviction of occupant filed before the High Court was transferred. Now, Bombay High Court, some of you know, it has got the original jurisdiction also. So suit for eviction and suits for money can be filed before the Bombay High Court in its original jurisdiction. In this particular case, suit for eviction of a tenant, not a tenant, but of the occupant, was filed before the Bombay High Court. But then the Bombay High Court, the judge who came to deal with the suit, found that the suit was not maintainable. According to him, the suit was maintainable before the small cause court, and it was transferred. And the point now decided is, suit for eviction of the occupant filed before the High Court was transferred to small cause court when the defendant was already on record. Transfer was effected when the defendants were already on record, but still the defendants are not stopped from questioning that transfer at any stage. They are not stopped from questioning transfer at any stage. Now, I think it will be necessary to take you to the facts a little. Not fact, but the discussions of Justice Naidu here pertaining to how the Estoppel, how he deals with Estoppel. Yes, issue number one was this. The plaintiff filed a suit before one forum. One forum means here it was the Bombay High Court in the original jurisdiction, and put the defendant on notice. But that forum ruled that it had no jurisdiction. Instead, it transferred the file to the forum which it felt has the jurisdiction. Does this stop the defendant from questioning the plaintiff's choice if it were a forum? Question. Then, the consideration of this particular issue by Justice Naidu. This issue, para 60, this issue concerns the small cause court's inherent jurisdiction to entertain the suit. Vaishala first invoked this court's original jurisdiction and filed the suit before it. Vaishala, Vasanthi and her husband entered appearance. Before they could file their defense, this court on its own reckoned that the suit ought to be filed by the small cause court. So it sent the suit to the small cause court. The order, in fact, reads, the transfer order is quoted. This suit is for recovery of possession and mean profits from gratuitous licensee. The civil court, I am quoting the order, the civil court has no jurisdiction to try the suit. Papers and proceedings are sent to the small cause court Bombay for continuation of trial. Then, para 17, from the above order, I gather that this court has not returned the plaint. Rather, it has transferred the suit and it ordered continuation of the suit at that. Had it been a case of return of plaint, it would have been governed by Order 7, Rule 10 CPC. Now, therefore, we need not labor on that provision. Indeed, to transfer a suit general is governed by section 22-25. And then there is a discussion on that. The powers of the court to transfer suits. And then in para 20, here I have already noted that this court invoked section 24 of CPC and transferred the case. Then I must hold that the transfer was effected when the defendants were on record. Put differently, defendants were parties to that decision of transfer, but still the defendants are not stopped from questioning that transfer at any stage. First, neither any court nor any consenting party can confer jurisdiction on a court which otherwise lacks it. Second, the inherent lack of jurisdiction goes to the root of the matter. And third, the order or the judgment of the transferee court may render is a nullity, a product of quorum non judice. That is, the proceedings are before a judge, but not the proper one, or one who cannot take judicial legal consequence of the matter. So the judgment too suffers for want of legitimacy. As a result, so that being the position, it's a fundamental question of jurisdiction, lack of even inherent jurisdiction. If that is the position, there is no estoppel at all. That is, the defendant can challenge it, even though it was a transfer by the court suo motu. Yes, so this is Naidu's view, and that seems to be correct also. Then I take you to Supreme Court judgment in Satyendra Kumar and others versus Rajanath Dubey. Satyendra Kumar and others versus Rajanath Dubey and others. The citation is AAR 2016 Supreme Court 2231. 2231. Judges are Deepak Misra and Shivakirti Singh. Judges on the bench are Deepak Misra and Shivakirti Singh. Now, their lordships are dealing with the questions of res judicata and issue estoppel. And important paragraph is 12, and this is what their lordships say. Res judicata, issue estoppel, and estoppel by judgment. Principles discussed behind. Discussed Evidence Act 115, 116, and 117. Held the distinction drawn by the High Court in the impugned judgment that an erroneous determination of a pure question of law in a previous judgment will not operate as res judicata in the subsequent proceedings for different property, though between the same parties, is clearly in accord with Section 11 of the CPC. Strictly speaking, when the cause of action as well as the subject matter, that is the property in issue in the subsequent suit, are entirely different, res judicata is not attracted and the competent court is not debarred from trying the subsequent suit which may arise between the same parties in respect of other properties and upon a different cause of action. In such a situation, since the court is not debarred, all issues, including those of facts, remain open for adjudication by the competent court, and the principle which is attracted against the party which has lost an important issue of fact in the earlier suit is the principle of estoppel, more particularly issue estoppel. Now, my request to all of you is that you should read the decisions pertaining to issue estoppel. It's a confused area which creates a lot of confusion. The distinction between issue estoppel, regular estoppel, res judicata. Anyway, here, this is what their lordships say. The issue estoppel, which flows from the principles of evidence, such as from Section 115, 160, and 117 of the Indian Evidence Act, and from the principles of equity. As a principle of evidence, estoppel is treated to be an admission, or in the eyes of law, something equivalent to an admission of such quality and nature that the maker is not allowed to contradict it. In other words, it works as an impediment or bar to a right of action due to affected person's conduct or action. Estoppel by judgment by reference finds reference in the case of Hassan Hussain Abdul Ali Bohani, proprietor Abidi Shop versus Maina, wife of Nathu Talanga, then 38 Nagpur 129. It is taken as a bar which precludes the parties after final judgment to re-agitate and re-litigate the same cause of action or ground of defense or any fact determined by the judgment. If the determination was by a competent court of competent jurisdiction, bar will remain operative even if the judgment is perceived to be erroneous. If the parties fail to get rid of an erroneous judgment, they as well as persons claiming through them must remain bound by it. Actually, I told you the other day also, estoppel by judgment is nothing other than res judicata, envisaged by section 11 of CPC. Then next note, 115, 116 and 117, estoppel. No equitable principle or estoppel can impede powers of the court to determine an issue of law correctly in a subsequent suit which relates to another property founded upon a different cause of action, though the parties may be the same. Section 11, held as explained and held by this court in the case of Mathura Prasad Sarju Jaiswal, where the decision is on a pure question of law, then a court cannot be precluded from deciding the such question of law differently. Such a bar cannot be invoked either on a principle of equity or estoppel. No equitable principle or estoppel can impede powers of the court to determine an issue of law correctly in a subsequent suit which relates to another property founded upon a different cause of action, though the parties may be the same. As explained earlier, in such a situation, principle of res judicata is strictly speaking not applicable. So far as principle of estoppel is concerned, it operates against the party and not against the court, and hence nothing comes in the way of competent court in such a situation to decide a pure question of law differently if it is so warranted. Issues of facts, once finally determined, will, however, stare at the parties and bind them on account of earlier judgments or for any other good reason where equitable principles of estoppel are attracted. So findings of facts, even if the judgment doesn't operate as res judicata, a finding of fact may bind the party as issue estoppel. That's what their lordship say. Then next decision. Next decision is yes, this is by my dear Chief Justice, Justice Telemesher and Abdul Nasir, Supreme Court decision. The citation is AR 2017 Supreme Court 3995. That is Justice Telemesher and Justice Abdul Nasir. The name of the case is Jaspal Kaur Shima and another versus Industrial Trade Links and others. This must be from Punjab and Haryana High Court. Yes, because this is from Chandigarh. Case is from Chandigarh. Yes. And their lordships say their lordships are dealing with section 116. That is the estoppel against the tenant from denying the landlord's title. Section 116 deals with estoppel of a tenant founded upon contract between the tenant and his landlord. It enumerates the principles of estoppel, which is merely an extension of the principle that no person is allowed to approbate and reprobate at the same time. The tenant who has been let into possession cannot deny his landlord's title. Yes. And para 11. The principle of estoppel arising from a contract of tenancy is based upon the principles of law and justice, that a tenant who could not have got possession but for a contract of tenancy admitting the right of the landlord should not be allowed to put his landlord in some inequitable situation, taking undue advantage of the position that he got and any probable defect in the title of the landlord. This court in Bensiraj, Lalda Prasad Mishra versus Stanley Parker Parker Jones, 2006, 3 SEC 91, enumerated the policy underlying Section 116 as follows. Then quoted from 2006, 3 SEC 91, the underlying policy of 116 is that where a person has been brought into possession as a tenant by the landlord, and if that tenant is permitted to question the title of the landlord at the time of the settlement, that will give rise to extreme confusion in the matter of relationship of the landlord and tenant. And so the equitable principle of estoppel has been incorporated by the legislature in the said section. The principle of paragraph 14, the principle of estoppel arising into the contract of tenancy is based upon a healthy and salutary principle of law and justice, that a tenant who could not have got possession but for his contract of tenancy admitting the right of the landlord should not be allowed to launch his landlord in some inequitable situation, taking undue advantage of the possession that he got and any probable defect in the title of the landlord. It is on account of such a contract of tenancy and as a result of the tenant's entry into the possession and on the admission of the landlord's title that the principle of estoppel is attracted. Then section 116 enumerates the principle of estoppel, which is merely an extension of the principle that no man is allowed to approbate and reprobate at the same time. And their lordships are then dealing with other decisions of Supreme Court yes, they are dealing with Tangappan versus Padmavati, etc., etc. Then now I take you to the judgment of the Supreme Court in Shri Sidbali Steels Limited, Messrs. And others versus State of UP and others. The citation is AR 2011 Supreme Court 1175. 2011 Supreme Court 1175. Learned judges on the bench are Justice J.M. Panchal, B.S. Chauhan, and Gyan Sudha Misra. Yes. The important points are in para 11, 14, and 18. I'm not reading those paras in full because I will run out of time, short of time. Yes. Evidence Act 115, promissory estoppel, principle of there can be no estoppel against a statute. The government authority cannot be compelled to do something which is not allowed by law or prohibited by law. Doctrine of promissory estoppel cannot be invoked for enforcement of a promise made contrary to law. Where public interest warrants, principle of promissory estoppel cannot be invoked. In view of the observations made by the division bench of this court in the reported decisions, the questions that fall for consideration before this larger bench are whether a benefit given by a statutory notification can be withdrawn by the government by another statutory notification, and whether the principles of promissory estoppel would be applicable in a case where concessions and rebates given by a statutory notifications are subsequently withdrawn by another statutory notification. It is an admitted position that the notification dated 28th June 1996 granting rebate to the industries set up in hill areas was issued in exercise to the powers conferred under Section 49 of Electricity Supply Act 48. By the said notification, rebate in electricity charges to the extent of 33.33% was given to the industries which were set up in the hill areas during the specified period. It is also an admitted position that thereafter, by notifications dated 18th June 1998 and January 25th, 1999, issued in exercise the powers conferred by Section 49 of Act of 1948, percentage of rebate granted by the earlier notification was reduced to 17%. However, by subsequent notification dated 7th August 2000, the benefit which was granted to industries set up in the hill areas regarding rebate in electricity charge was completely withdrawn. What is relevant to notice is that it is not in dispute that the notification dated 7th August 2000 withdrawing the benefits granted earlier was issued in exercise of the powers conferred by Section 24 of the Uttar Pradesh Electricity Reforms Act. The above mentioned fact makes it evident that the benefits which were granted and slash or curtailed in exercise of statutory powers were subsequently withdrawn in exercise of another statutory power conferred by another statute, namely UP Electricity Reforms Act. In the light of the above mentioned facts, the question whether principle of promissory estoppel would apply to exercise of statutory powers will have to be considered. Doctrine of promissory estoppel is by now well recognized and well defined by catena of decisions of this court, where the government makes a promise knowing or intending that it would act on the it would be acted on by the promisee, and in fact the promisee acting in reliance of it alters his position, government would be held bound by the promise, and the promise would be enforceable against the government at the instance of the promise. Will be enforceable against the government at the instance of the promisee, notwithstanding that there is no consideration for the promise and the promise is not recorded in the form of a formal contract by Article 229 of the Constitution. The rule of promissory estoppel, being an equitable doctrine, has to be molded to suit the particular situation. It is not a hard and fast rule, but an elastic one, the objective of which is to do justice between the parties and to extend an equitable treatment to them. Them means both the government authority as well as the promisees. This doctrine is a principle evolved by equity to avoid injustice, and though commonly named promissory estoppel, it is neither in the realm of contract nor in the realm of estoppel. For application of doctrine of promissory estoppel, the promisee must establish that he suffered in detriment or altered his position by reliance on that promise. Normally, doctrine of promissory estoppel is being applied against the government, and defense based on the executive necessity would not be accepted by the court. However, if it can be shown by the government that having regard to the facts as they have subsequently transferred, it would be inequitable to hold the government to promise to the promise made by it, court would not raise an equity in favor of the promisee and enforce the promise against the government, where public interest warrants principle of promissory estoppel cannot be invoked. Government can change the policy in public interest. Then next decision is from Kerala High Court. Kerala High Court, this is learned judge, a division bench. Learned judges are Justice Hariprasad, whom most of you know because he has taken classes on this particular Beyond Law CLC platform. A. Hariprasad and T.V. Anil Kumar. T.V. Anil Kumar, both of them have retired from Kerala High Court now. The citation is, I give you ILR citation, ILR 2021 1 Kerala 966. No, this was a case where yes, I will just read it. Execution of sale deed with a condition. Execution of sale deed with a condition for reconveyance. Failure of the defendant in reconveyancing the property. Whether a suit for declaring the sale deed as a sham document is maintainable. A suit for declaring the sale deed as a sham or void document is not maintainable when there was failure on the part of the defendant in executing the deed of reconveyance. Appropriate remedy open to the aggrieved is to sue for execution of the deed for reconveyance or property, as in the case of a suit for specific performance. Then a demand being made to the defendant in the suit for execution of deed for reconveyance must necessarily imply. Now that's the principle. Their lordships are saying that there is estoppel against the plaintiffs in suing for a declaration that the suit is sham, that the sale deed is sham, because they had admitted the execution of the sale deed and containing in which a condition that there will be reconveyance when the money is paid off. Then yes, demand being made to the defendant in the suit for execution of the deed for reconveyance must necessarily imply the plaintiff's admission as to the transfer of his rights to the defendant in the past. Expression reconveyance denotes a demand made for retransfer of rights which has already taken effect through a deed in favor of the transferee. A suitor cannot blow hot and cold that the conveyance has not taken into effect and yet he is entitled to reconveyance of the rights. Such a contention is mutually contradictory and cannot go in tandem. A plaintiff having pleaded in his plaint that defendant agreed to reconvey the property on receipt of the loan amount back, is stopped by his act from contending that the sale deed executed by him was not intended to take effect and was therefore sham. No court will be in a position to declare a sale deed executed in such circumstances to be sham or nominal. In fact, this is estoppel by pleading. Having pleaded that I have executed a sale deed containing a clause that they will reconvey it, then he cannot say the sale deed is sham. But he should say there is a condition for reconveyance. He is not complying with the condition. Therefore, give me specific performance. Command him to reconvey to me. That is the remedy. But to say that, if he says that this is a sham document, that goes against his own averment in the plain that he had executed a sale and the deed contained a clause. So that is the principle of Kerala decision. Then, next decision is Supreme Court. This is learned judges are Justice R. Bhanumati, and then A.S. Bopanna, and Hrishikesh Roy. Hrishikesh Roy was Kerala Chief Justice, everybody knows. Then Justice Bhanumati was President of the Madras Judicial Academy, and I had occasion to stay in the Madras Judicial Academy's guest house when she was the president. She insisted that I should stay in their guest house rather than the government guest house. A nice woman who was very friendly towards me. Now, the principle is this. The case is Santosh Chaturvedi versus Kailash Chandra and another. Santosh Chaturvedi versus Kailash Chandra and another. Then citation is AR 2020 Supreme Court 270. Then this is yes, UP Section 116 Evidence Act. Then UP Regulation of Letting Rent and Eviction Act, UP Rent Control Act. It is. Father of the owner had received property under a registered partition deed. Though detailed examination with regard to the nature of the right to the property has been made in the present case, the same was wholly unnecessary in a summary proceeding in the present nature. Because when the tenant had not set up title to the premises in question, family settlement deed dated 15/11/1919 was entered into to which the father who was the owner was himself a party and had given a portion to his properties to his son. Settlement deed entered by the owner in favor of his son, landlord acquiring title, cannot be called in question by the tenant. So that is what the Lordship Supreme Court in this judgment say. But then we have seen other judgments already, and I think there may be other, because that is, even though the tenant is not entitled to deny the title of the landlord, tenant is not prohibited from denying the derivative title of an assignee landlord. But then here, their lordships are drawing a distinction. This son who got the property from his father, he occupies a higher pedestal than that of an ordinary assignee landlord. It should be like that. So 116 applies. That is what Justice Bhanumati and the other learned judges say. Now, I take you to yet another decision of Supreme Court. This is Century Spinning and Marketing Company Limited and another versus Ulhasnagar Municipal Council and another. The citation is AR 1971 Supreme Court 1021. Judges are J.C. Shah, then K.S. Hegde, and A.N. Grover. Paragraphs 10 to 13. Yes. 1 minute. Yes. I'm reading from paragraph 10. There is undoubtedly a clear distinction between a representation of an existing fact and a representation that something will be done in future. The former may, if it amounts to a representation as to some fact alleged at the time to be actually in existence, raise an estoppel if another person alters his position relying on that representation. A representation that something will be done in the future may result in a contract if another person to whom it is addressed acts upon it. A representation that something will be done in future is not a representation that it is true when made. But between a representation of a fact which is untrue and a representation expressed or implied to do something in future, there is no clear antithesis. A representation that something will be done in future may involve an existing intention to act in future in the manner represented. If the representation is not acted upon by another person, it may, unless the statute governing the person making the representation provides otherwise, result in an agreement enforceable at law. If the statute requires that the agreement shall be in certain form, no contract may result from the representation and acting therefore, but the law is not powerless to raise in appropriate cases an equity against him to compel performance of the obligation arising out of the representation. Then para 11, public bodies are as much bound as private individuals to carry out the representations of facts and promises made by them, relying on which other persons have altered their position to their prejudice. The obligation arising against an individual out of the representation amounting to a promise may be enforced ex contractu by a person who acts upon the promise when the law requires that a contract enforceable at law against a public body shall be in a certain form or be executed in the manner prescribed by the statute. The obligation of if the contract may not be in that form, may be enforced against it in appropriate cases in equity. Then in Union of India versus so-and-so, this court held that court is not exempt from the equity arising out of acts done by citizens to their prejudice, relying on the representations as to future conduct made by the government. Then their lordships are quoting Denning, Lord Denning in Robertson versus Minister of Pensions. The Crown cannot escape by saying that estoppels do not bind the Crown, for that doctrine has long been explored. Nor can the Crown escape by praying in aid the doctrine of executive necessity, that is the doctrine that a Crown cannot bind itself so as to better its future or future executive action. Then their lordship say, paragraph 12, in our nascent democracy, if our nascent democracy is to thrive, different standards of conduct for the people and the public bodies cannot ordinarily be permitted. A public body, in our judgment, is not exempt from the liability to carry out its obligation arising out of the representation made by it, relying upon which a citizen has altered his position to his prejudice. Now, I will let me continue my lecture for 10 or 12 minutes. Then there are a few more decisions. If I am unable to complete the other decisions, the remaining decisions, I will give citations, only that. Because, you know, today being a Sunday, Vikas is very particular that I must stop at 1 hour, in 1 hour. Yes, you know, in continuation of my lecture, estoppel by different categories. Let us deal with certain other categories of estoppels known to law, that is referred to in judgments and applied in decisions. Estoppel by judgment. Estoppel by judgment, I have already told you, it is virtually the res judicata under section 11. Then estoppel by laches. Estoppel by laches. Estoppel by laches belongs to the category of estoppel in pay. Pay, I said P-A-I-S, to be the pronunciation is pay. P-A-I-S. Latch means an unreasonable delay in making an assertion or claim which may result in refusal. A party to a contract delays in performing the contract, thus causes loss to the other party, is said to be latches on the part of the party delaying. It will disentitle him to claim the right under the contract. The delay may cause abandonment of his part of the contract. This is estoppel by latches. That's a part of estoppel in pay. Then third, estoppel by negligence. I had just in passing referred to negligence yesterday also, the other day also. Estoppel by negligence. This estoppel also belongs to the category of estoppel in pays. Estoppel by negligence is where a man is estopped by another man's misrepresentation if in breach of some duty to the person deceived, he has supplied the person making the representation with that which was necessary to make it credible. So that is estoppel by negligence. Then estoppel by warranty. Estoppel by warranty. Estoppel by warranty also belongs to the category of estoppels by deed. It is based on the principle of giving effect to the manifest intention of the grantor appearing on the deed as to the lands or estate or even goods to be conveyed, and of preventing the grantor from derogating or destroying his own grant by any subsequent act. So this is estoppel by guarantee. Then next, technical estoppel. This technical estoppel, these names I got from textbooks, but then they are not referring to any decisions. But anyway, textbooks by seasoned authors, celebrated authors on law of evidence, they say there is a category by name technical estoppel. So if somebody, for people who, youngsters who aspire for judicial examination, suppose the interview board asks you, what do you mean by technical estoppel? You can say this. Technical estoppel, estoppels are those which arise from matter of record or the deed of the party estopped. Estoppels arising from a strict or technical construction of the rules of law. Technical estoppels also belong to the category of estoppels by deed. Then, yet another category, title/right by estoppel. Title/right by estoppel are those where a person without title having conveyed with a warranty, with an assurance that he has title, but he actually was not having title, but he subsequently acquires title. That title will inure to the benefit of the grantee, who is said to acquire estoppel, acquire title by this estoppel or estoppel by right. I told you the other day I had mentioned about feeding the grant by estoppel. This is nothing other than feeding the grant by estoppel, which is in fact statutorily incorporated in section 53 of the Transfer of Property Act. Feeding the grant by estoppel was a question which we used to ask in our quiz competitions. So this is so title by estoppel or right by estoppel is feeding the grant by estoppel, statutorily recognized in section 53 of the TP Act. Now we come to promissory estoppels. Of course, most of the decisions which I dealt with were promissory estoppel, but I think some more lecture on the topic is necessary, because that is the topic where there is abundance of case law. When you go through the case law, you will find, whether it be of the Supreme Court or the various high courts, courts have mostly dealt with promissory estoppels, which are not regular estoppels contemplated under section 115, 116 or 117 of the Evidence Act. Promissory estoppels arise when there is a promise which promisor should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promisee, and which does induce such action or forbearance, and such promise is binding if injustice can be avoided by enforcement of the promise. The object of promissory estoppel is to preclude perpetration of fraud or causing injury in a case where the representation or promise has been made to induce an action on the part of the party setting up the estoppel. In such a case, the party making the promise is precluded from asserting want of consideration. Therefore, before the doctrine of promissory estoppel is invoked, it has to be shown, one, that there was representation or promise in regard to something to be done in future. Then two, that such a representation or promise was intended to affect the legal relations of the parties and to be acted upon accordingly. And three, that it is one on which the other side has, in fact, acted to his prejudice. Sometimes there may not be any agreement or contract in the 6 sense of the time, but a person making a promise may become bound by the rule of promissory estoppel. Then, estoppel by waiver, that I have discussed already, but then that is also another category of estoppels. Actually, estoppels and waiver differ from each other in various material aspects. Waiver means to refrain from or insisting on or applying a right or claim. Waiver is an intentional relinquishment of a right or such content. waiver creates substantial right as soon as it is made. Estoppel is a rule of evidence. It may indirectly create a substantial right, especially where a party intentionally or need an agreement or need a settlement waives his right in favor of another party. He is said to have waived his right. However, once he has waived, when he has waived his right in a contract or property, he cannot claim it later. But if he claims again, the estoppel by waiver comes into operation. In fact, estoppel by waiver belongs to this category of estoppel. Yesterday, in fact, the other day, while dealing with estoppel by waiver, I said about a case by an advocate who had joined practice after his retirement from government service, and he claimed the benefits of the welfare fund, but Bar Council denied it. But then his senior counsel, set up estoppel by waiver against the Bar Council. The argument was that the Bar Council, having received contributions from this advocate, cannot now turn around and say there is a rule which prevents advocates of age above a particular age cannot be members of the. But then I had said that the Kerala High Court had decided, upheld the argument of estoppel by waiver. Actually, I was wrong. That was the impression given to the advocates. But then the learned judge, what the learned judge ultimately did was, when he delivered judgment, what he did was, it was reserved. And the actual judgment is, he doesn't decide on merits. He found that there was a statutory remedy available to the advocate under the Advocates Act. And the advocate was relegated to the statutory remedy. And then, of course, observed, after he avails the statutory remedy, he can come to this court again. So I was not correct in saying that the Kerala High Court has held up a plea of estoppel by waiver against the Kerala Bar Council. That's not correct. I'm sorry for having made such a wrong statement of fact last time. Now, estoppel. Now we have estoppels by election. When a party has two options in a given circumstance, but not to choose both of them and chooses one of them, thereafter, he is precluded to claim the other option or both the options. He is thus precluded by estoppel by election. Estoppel by election, where a party has two options in a given circumstance, but not to choose both of them, chooses one of them, thereafter he is precluded to claim the other option or both the options. Now, in fact, there is a directly Kerala decision on this, and that is P.J. Kurian versus Ranjitha and others. I have got that decision. I will be taking to that. This estoppel by election, Kerala decision. Then issue estoppel. Issue estoppel. Then all the principles applicable to yes. Now I take you to issue estoppel. Where an issue of fact. What is issue estoppel? Where an issue of fact has been tried by a competent court on a former occasion, and a finding has been reached in favor of one party, such a finding would constitute an issue estoppel, not as a bar to the trial and conviction of the accused for a different and distinct offense. Now, issue estoppels apply to criminal proceedings also. Conviction of the accused for a different and distinct offense, but as precluding reception of evidence to disturb the finding of fact already entered into in the previous occasion when the accused is tried subsequently, even for a different offense which might be permitted by law. This is the principle in Masood Khan versus State of UP AR 1974, Supreme Court 28. I think I have brought Masood Khan also. Then all the principles applicable to reciprocate under section 11 will apply to issue estoppels also. Parties, that is not fully correct, not all the principles, but most of the principles. Parties in the two proceedings must be same. Facts in issue proved or not in the earlier trial must be identical with what is sought to be reiterated in the subsequent issue estoppel. Then the distinction between issue estoppel and the rule of double jeopardy. There is difference. In the former issue estoppel, only an issue relating to a fact is proved or disproved in the earlier proceeding. It operates as a bar in the subsequent proceeding from trying the very same issue. But in the latter, that is double jeopardy, the accused is convicted and tried for the same offense, and there cannot be further trial and conviction for the same offense. Now let me straight away, because I am running short of time, let me come to the decision. Yes. Now the first decision which I take you to now is the judgment of Justice Bhagavati, P.N. Bhagavati and Tulsapurkur, in reported in citation is our topic is that way. Scope and ambit of waiver. It is elementary that waiver is a question of fact and it must be properly pleaded and proved. There can be no waiver unless the person who is said to have waived is fully informed as to his right, and with full knowledge of such right, he intentionally abandons it. Then another principle, not very much relevant to us, but then you should know that, because the maxim ignorance of law is no excuse. Everybody knows ignorantia juris non excusa. But their lordships say that is there, but there is no presumption that every person knows the law. No such presumption. No presumption in law that every person knows the law. Though there is a rule that ignorance of law does not excuse. Then Estoppel, where the government makes a promise knowing or intending that it would be acted on by the promisee, and in fact, the promisee acting in reliance of it alters his position, the government would be held bound by the promise, and the promise would be enforceable against the government at the instance of the promisee, notwithstanding that there is no consideration for the promise, and the promise is not recorded in the form of a formal contract as required by Article 299 of the Constitution. If a promise is acted upon, such action in law must necessarily result in alteration of position. Then, 1 minute. It's a very lengthy decision. 79 decision, but then if you read this, you will get clear idea, because this subject on which I am taking classes now, abstract legal principles, not very easy. Because decisions themselves confuse. There is contradiction between decisions, conflicting decisions. So you have to be very cautious. You have to be very carefully read through the full text of the judgments which I cited. If you do that, then you will have a somewhat clear idea as to the doctrine of Estoppel. Yes, para 6, waiver. Waiver, they say they are quoting from Halsbury's Laws of England. I am not reading it because we don't have time. Then their lordships are referring to English decisions to drive home the point that there is no law, that there is no rule that everybody knows the law. Then paragraph 7. That takes us to the question whether the assurances given by the fourth respondent on behalf of the state government that the appellant would be exempt from sales tax for a period of 3 years from the date of commencement of production could be enforced against the state government by invoking the doctrine of promissory estoppel. Though the origins of the doctrine of promissory estoppel may be found in Hughes versus Metropolitan Railway Company, it was only recently in 1947 that it was rediscovered by Lord Justice Denning, as he then was, in his celebrated judgment in Central London Property Trust Limited versus High Trees House Limited. This doctrine has been variously called promissory estoppel, palabala pera, promissory estoppel, quasi estoppel, then new estoppel, same, everything is same wine in different names. Only the new estoppel, it's a principle evolved in equity to avoid injustice. And though commonly called a promissory estoppel, it is, as we shall presently point out, neither in the realm of a contract nor in the realm of estoppel. It's interesting to trace the evolution of this doctrine in England and to refer to some of the English decisions in order to appreciate the true.
Sir, it's not audible. Justice Pius, sir, it's not audible.
Law. The early cases did not speak of this doctrine as Estoppel. They spoke of it as raising an equity. Lord Kane stated, etc., etc. Then, later, their lordships say these observation of the Lord Denning clearly suggests that the parties need not be in any kind of legal relationship before the transaction from which the promissory estoppel takes its origin. The doctrine would seem to apply when there is no pre-existing legal relationship between the parties, but the promise is intended to create legal relations. Halsbury's Laws of England, etc. Then, of course, it must be pointed out in fairness to Lord Denning that he made it clear in the High Trees case that the doctrine of promissory estoppel cannot found a cause of action in itself, since it can never do away with the necessity of consideration in the formation of a contract. But it totally repudiated in Evenden's case the necessity of a pre-existing relationship between the parties, and pointed out in Crabb versus Arun District Council that equity will, in a given case where justice and fairness demand, prevent a person from insisting on strict legal rights, even when they arise not under any contract, but on his or title deed or under statute. Very length. 1 minute. My request to all sincere students of law is to go through this decision in full, because I have no time to read them in full. Now, paragraph 14. Paragraph 14, the lordships are discussing the American law. The American law relating to estoppel. And then they come ultimately to Indian law. Yes. Indian law, and in the discussions about Indian law, this is what they say. Under our jurisprudence, the government is not exempt from liability to carry out representations made by it to future conduct, and it cannot, on some undefined and undisclosed ground of necessity or expediency, fail to carry out the promise solemnly made by it, nor claim to be judge of its own obligation to the citizen. The law, therefore, now be settled as a result of this decision, that where the government makes a promise, knowing or intending that it would be acted upon by the promise, that the promise would be enforceable against the government, and at the instance of the promise, notwithstanding that there is no consideration for the promise, etc., etc. It is elementary that in a republic governed by the rule of law, no one, howsoever high or low, is above the law. Everyone is subject to law as fully and completely as the other, and the government is no exception. It is indeed the pride of constitutional democracy and the rule of law that the government stands on the same footing as a private individual, so far as the obligation of the law is concerned. The former is equally bound as the other. Then government cannot claim to be immune from the applicability of the rule of promissory estoppel and repudiate a promise made by it on the ground that such promise may fetter its future executive action, etc., etc. It is necessary to point out, etc. It's a wonderful decision, very lengthy decision, and I think the author is Justice Bhagavati. Let me see. Should be Bhagavati. That's not very clear. I think it should be Bhagavati, because the language, the style is that of His Lordship Justice P.N. Bhagavati. Read it in full. I have no time. Then, which is the other one? Citation, repeat, Citation is 1979, AR 1979, 621. Motilal Padampat Sugar Mills Company Limited versus State of UP. Bhagavati and Tulsapurkar. Another decision. Now another decision. I think it is 1 minute. I will just give the citations. Because I'm sorry. Then Masood Khan versus State of UP, referred to in the earlier decisions. HR Khanna, HR Khanna is on the bench. HR Khanna, Alagirisamy and R.S. Sarkaria. This is not Justice Khanna. Alagirisamy is the author of the judgment. This is 74-3 SEC 469. Please note down. Masood Khan versus State of UP. This is what is the principle? This is equitable estoppel, issue estoppel, very good decision. Please read through this. Now, 11. Yes, next decision. This is Supreme Court decision 1980, Supreme Court 1255. 80 Supreme Court 1255. Please note down the citation. NC Singhal, Doctor versus Union of India and others. Judges are D.A. Desai and E.S. Venkatramaiah. What the point is, affidavits by government, admissions in the affidavit filed by the government, which are mere expressions of opinion, limited to the context and do not contain specific assurances, are not binding on the government or create any estoppel. So when the affidavit is filed by the government for the purpose of avoiding orders, you should see that the affidavit is in the form of solemn, clear undertakings or assurances. Otherwise, this judgment will be applied and they will say this is not binding on the government. Yes. Now the other decision. Yes. Now next decision is again by D.A. Desai and R.B. Misra. This is citation is AR 1983 Supreme Court 848. The D.A. Desai and R.B. Misra case is Gujarat State Financial Corporation versus Messrs. Lotus Hotels Private Limited, promissory estoppel. Gujarat Financial Corporation entered into agreement in performance statutory duty to advance loan to a company. Company incurred huge expenses, etc., etc. Held a promissory estoppel could stop the corporation from backing out, etc., etc. With this, now the last decision. This is important. This is by a learned single judge to the Kerala High Court. This is Kurian versus Ranjitha. The Malayali lawyers know who this Kurian is. I'm not going to mention his name. And this case was, hit the headlines in those times. I'm not saying this, but this is a case where their lordship say, his lordship says, learned single judge, Justice K.M. Mohammed Shafi, his lordship says that the principle of estoppel by election will apply to civil as well as criminal proceedings. Because here, the other side argued that since there was an OP already pending, this section 482 under the Criminal Procedure Code petition, miscellaneous petition filed by this Kurian for quashing the FIR, that case is not maintainable because they have already invoked the writ jurisdiction of the High Court in the other writ petition where the subject matter same. But then the learned single judge says estoppel by election. But then the question arose whether the principle of estoppel by election will apply to criminal cases. The public prosecutor's argument, it appears, was that his lordship says it will apply to following English textbooks. His lordship says it will certainly apply, but on facts, he said, on the facts of this case, it will not apply. He said 482 petition is maintainable in law, notwithstanding the other writ petition, but he did not allow the 482 petition, and it was dismissed. Kurian's criminality was dismissed, and Kurian had to go to the Supreme Court. And if I understand correctly, before the Supreme Court, he engaged Justice, the senior advocate Arun Jaitley, then now minister, and Jaitley won the case for Kurian. Jaitley could get the FIR quashed. Mr. Vigas, I'm sorry that, Mr. Vigas, are you there? Mr. Vigas, I'm sorry that I could not complete it, but then I think I have given the citations. the participants, I'm sure, will read the full text of the citations given, and any specific questions, you do one thing, you just send me the questions, I will try to answer. Then being a topic being abstract legal principles, I cannot straight away answer, but then you give me, I will on the basis of textbooks and decisions, I will answer. But here also, decisions, every decision is, when we read one decision, you will find that is contrary to it. This is the confusion. But still, I think to a great extent, to the best of my ability, I have done justice. That's what I believe. So thank you, Mr. Vikas, and thank you all dear participants for the patient listening. I think time that I should say stop this. Yes.
Like what you said, the Estoppel has its own legal journey. I remember I went to one senior advocate's office way back around 25 years ago. At his office, at the entrance gate where you enter his office, it was written, the law is what is decided on that particular day. So that's how the law has traversed with the flux of time. And I would request you, sir, that if you could give the entire compendium of the judgment with citation, not the judgments as such, we will share it in the WhatsApp group. So that they can, let's assume somebody has missed it or somebody watches it on
Decisions I have already given. Decisions I have already given. Almost
so
all
in a compendium form, a title plus citation.
Okay.
That your associate could create it.
I will Vikas. Okay.
Right, sir. Thank you, sir, and thank you, everyone. Stay safe, stay blessed, and it's always a pleasure hearing from you. Namaskar. Thank you.
Okay.